I came to the study of philosophy, politics, the law, because I wanted to raise a critical awareness, raise consciousness about how some of these inequalities are systematically and structurally embedded within our social, political, and legal institutions. My main motivations are the principles of justice, freedom, and equality for the marginalized, for those that are arbitrarily disadvantaged because of their gender, their disability, their ethnicity, or their culture. Well, there's been so many different contemporary frameworks within which to deal with questions of diversity and pluralism. I'm very interested in asking and examining whether and to what degree these kinds of theories can provide a realistic grassroots framework for intercultural dialogue regarding the various claims made by marginalized communities. And I want to argue that even if a community is based around more substantive views of the good life, does not necessarily mean that it cannot come to agree to certain basic minimal standards of what it is to live a minimally decent life. I argue that what's at stake in a cross-cultural ethic of well-being is the cross-cultural prohibitions against certain sorts of conduct, slavery, torture, and other such abuses, and the cross-cultural prescription of other forms of conduct, equality, assuring food, clothing, shelter, and care for each. I argue that these underlying norms can be separated from the language and particularized philosophy of certain kinds of discourses. How a society formulates or justifies these underlying norms and the sorts of philosophical views of agency in society that these formulations presuppose can acceptably vary from culture to culture. Well, one of the things that I've tried to do in my work is based on the Hegelian notion that difference doesn't necessarily mean opposition, that to be not liberal or from a Euro-Western perspective does not mean somehow that one's framework is inherently unjust or oppressive or anti-liberal. And I am interested in how, and often surprised, how many of these current theories of justice, of liberal justice, are rooted in epistemological and ontological assumptions which prove to be problematic in the pluralistic context and that may hinder meaningful dialogue and equality when it comes to actual policy and practical application of these theories. So, for example, there are various theories about how to approach the relationship with Indigenous communities in Canada, but often what is left out are these kinds of implicit assumptions that, for example, about property and agency and the relationship between property and agency. For example, we assume that property is a fungible resource, that it's a commodity, and that it can be bought and sold. I think that one of the most interesting things I've ever heard was this the Aboriginal leader when he said, "Look, our ancestors didn't make a real estate deal with the crown. In fact, they wanted to share their stewardship relationship with the crown." And I think that questions such as these need to be explored, especially because they constitute, certainly private property and land as property, constitute a foundational legal premise upon which our whole structure, our whole legal and economic structure is in part founded.